All right. Hold on. What? All right. I had to fix it. All right, y'all. We're here. Sorry, I had a little bit of a technical glitch happen. But we're here. And say hi to Kirby. He's back. Oh, wait. Am I pointing the right way? He's back.
Right.
And today, like I said, we about, what was that, like 2-3 weeks ago? Harvey Weinstein's oh Lord, what year was that? Was that 2020? Yes, 2020 conviction for his, sex crime that spanned over decades was overturned by the appeals court in New York, which is the same jurisdiction that obviously Jonathan Majors would be up against when and if he files his appeal. And in part, but of significant note, was because of Molineux evidence that was used against him during his trial. And so that caused his appeal to be, in part, caused his appeal to be granted, and he's going to get a new trial. So obviously this Jonathan Major situation is nothing like Harvey Weinstein's in terms of the why, but similar in the how as it relates to what the overarching political agenda was and the evidence that was presented at the trial, because Molineux was allowed in, it was allowed in due to what can be perceived as a defense error, inadvertent error. And so that's what we're going to talk about, in addition to other things. But this is kind of like we're using the Harvey Weinstein, the overturning of the Harvey Weinstein 2020 conviction as our kind of starting point or reference point for what appeal options Jonathan has. We discussed this the very, very first time Kirby and I spoke. There's a litany of different options he has to appeal with, but this is definitely one that he can use and possibly use as precedence, as part of several other points. So let me do my intro, and then we will get to what we came to talk about. All right, we're back. Sorry, I'm sorry if I seem a little fragile. I'm really overstimulated today, so you gotta excuse me. I'm using my clinical terms now. I told you, every time that I'm with you guys, I warn you, I have ADD. And today I'm hyperstimulated because I had to go outside. And that's something I don't like to do a lot. And yesterday I got stuck in the Miami airport, so that's why we couldn't do this yesterday. So I'm kind of, still trying to regroup and get back to my normal calm. But let me just say hi real quick to everybody that is here right now. We got Flavio. Hey, Flavio. Hey, James. Hey, Quicksilver. Hey, Monique, Earl, and Daisy. All right, guys. So as usual, ground rules: when we're live with a guest, we have to respect their time. Kirby was so gracious to join us. He's still in his office, so we would like him to be able to go home at some point tonight. So we are going to respect his time. We are going to keep the questions on topic. Please don't start discussing other things. If you do, you can do it amongst yourself. But don't ask him questions that have nothing to do with what we're talking about today, because we do want him to be able to go home. All right. And I don't want a stream that's longer than an hour and a half, tops 2 hours, because that's just way too long. I know you guys love Kirby. I love Kirby, but I don't know if everybody loves watching a 3-hour YouTube stream. So, hey, Barbara. Okay. So we're going to get started. I don't know what I'm doing right now because, like I said, I'm a little frazzled-ish. So let me see. I guess first we're going to start with, excuse me, some of these headlines that have been, some of these headlines that came out regarding Harvey Weinstein. Off of the 2020 conviction. I don't know if he got out of jail, but he will be getting a new trial granted to him. And so, just really quickly, I'm gonna go over really quickly what Molineux Evidence is, just so that you guys can understand it. And then obviously, how do I keep saying Kirby? Kirby is going to translate it into regular layman's terms that we can understand. Okay, so basically, the legalese behind it is it's evidence of crimes and wrongdoing. So basically, prior bad acts is the layman's well, it's a legal term, but it's a more understandable term. Basically, evidence of crimes, wrongs, or other acts committed by a person that is not admissible to prove that the person acted in conformity therewith on a particular occasion or had a propensity to engage in wrongful acts or acts. This evidence may be admissible when it is more probative than prejudicial to prove. For example, motive, opportunity, intent, preparation, common scheme or plan, knowledge, identity, absence of mistake or accident, or conduct that is inextricably interwoven with the charged acts, or to provide necessary background information or explanation, or to complete the narrative of the subject, event, or matter. In a criminal proceeding where the defendant interposes a defense, the people on rebuttal may prove the defendant's commission of other crimes or wrongs when such crimes or wrongs are relevant and probative to disprove the defense. Okay, so that was a lot, but it also is a throwback to what we talked about in our first stream and in subsequent streams in terms of probative value versus prejudicial value. Okay, so prejudicial value is where we want to hang our hat when we're talking about appeal, because it has to be proven that whatever evidence and background knowledge was presented during trial was prejudicial to the jury, to the detriment of the defendant. Okay, so I'm gonna let Kirby have his time. I guess put it in plain English. I think it was pretty clear, but I guess put Molineux in plainer English.
All right. Well, let me say it this way. In Georgia, we call it similar transaction evidence because Molineux is actually the case name.
Right.
They call it. So New York kind of goes everything by case names. You know, a map hearing. You know, if you want to suppress evidence that they retrieve from your person, so they call it by the case name. But the example I would use exactly as opposed to Molineux, because that only applies in that case is a New York case. Or right. You could have you might hear people say 404B evidence, which is under like a federal rule. But what it stands for is that you can introduce as a prosecutor in your case in chief, that is not on rebuttal, but as part of your case in chief, I'm going to introduce evidence of the defendant's prior criminal acts. They're not charged in the case right now. So you oftentimes hear them say uncharged criminal evidence, meaning it's not charged right now, but it is evidence that that helps them to show motive, intent. Let's use this example. So if a defendant were to testify, you know, it wasn't me, or they didn't testify, he wears a clown suit the whole time he does all his robberies, and they know that he's got 10 other robberies and this 11th robbery, and people go, well, I think it's him. Well, we're going to introduce as Molineux evidence at least one of those prior robberies where he wore a clown suit to prove like modus operandi. This is how you do your crimes. You wear a clown suit. Or remember Zorro, you know, I don't know nobody remembers Zorro now, but he would leave a Z. If he were a fugitive and he was being tried, they'd say, well, this guy carved a Z in my outfit with a sword. Well, you know what? this masked man, that's what Zorro does. So you would be able to introduce that. You can prove absence of mistake. For instance, it was a mistake. I didn't mean for it to happen. Well, funny thing, you did this 3 other times. And so we can now show that it wasn't a mistake. Or intent. And intent in New York is, let's suppose, like it is, and I'll talk about the Weinstein case in particular. The Molineux evidence they introduced were of women who said that they didn't have any relationship with him beforehand. He touched them, did all these various things. But in the case in chief, the women were like, no, there was a fight. I literally said no. I fought him off. I pushed him off. Well, and the court said, well, you don't need to introduce evidence to show intent or even to show that he needed to know that this was non-consensual, because in the case in chief, all of these women were like no and fighting him off. So there was no need for these other women who say, well, I looked away. He came on to me. I didn't say anything. They're like, well, don't, in the Molineux evidence, there was a question as to whether you were saying no or not. But in the case in chief evidence, there was none. They all said no, and they fought you. So it was not admissible that way. So when you think of Molineux or similar transaction evidence or uncharged crime evidence, think of it as it helps to show or disprove those things. And then, as that part 2 of the statute reference, on rebuttal, because the first part is case in chief. I'm putting my case in, all the way up to the state says the state or the people rest. That's the case in chief. Then the defense puts up a case. And now you can rebut. In rebuttal, you can bring in evidence, as the subsection 2 or B said in that, to disprove some element of the defense. Again, the same concept. It is all subject to these following principles. Number 1, you can't introduce prior bad acts to prove propensity. That is, this is just what you do. Can't do it.
Right.
Fair, because then the people aren't convicting you for what they allege that you did. They're convicting you because he's always doing this. Well, no, that should not relieve the prosecution of proving that he did this, because this might be the time he didn't do it. That's one point. The other part is whether the probative value is outweighed by the prejudicial impact of that case. Oh, hello, Ghost 4388881. He's probably on the screen.
No, right.
But made me lose my thought. It's vapor like a ghost. No, anyway. But the point being is that if the probative value, in order to be admissible, evidence has to be relevant. So it has to be probative of some fact. Mm-hmm. And so that's the first issue. If it's not probative of a fact, it's irrelevant. I don't care what you had for breakfast if the question is who robbed you. It's irrelevant. So it's not probative of any fact. But once we establish probity, then the next question becomes, well, is it too prejudicial? And in the case of Molineux, it's like, yeah, well, you want to introduce certain other things. Well, that's way prejudicial under the facts of this case. And it will make the jury convict the person, not because of what he's alleged to have done, but based on what you all proved that he did some time ago. That's Molineux or similar transaction evidence in a nutshell. Although it was a big nutshell, but still, there you go.
More like a lobster shell.
Yeah. I'm gonna be shorter next time.
No, you're fine. I'm just, you know where I stand on this whole thing.
Yeah, yes.
Hold on, let me. Okay, so before we even get started, can we please? I know I said I wasn't going to address any off-topic comments, but this one's hilarious, and I just, I guess they want to know your opinion on bad built, butch body, bleach blondes. I have blonde, but I'm not bad built with a butch body. So
I have to say that as boring as congressional hearings and debates are, that was spectacular.
Oh, she's a woman when I tell you that. You remember Denzel in Training Day when he leans back and he goes, oh, that's a woman after my own heart. Because when I tell you my clapback game is like bars, that right. was.
and the thing,
and the guy was like, a what now?
And that's what was really funny to me is because you had the chairman kind of going, what? And you're like, okay, clearly you run in different circles, But if you look to his right, that other senator or whoever was there, he was fighting laughter hard. And I'm like, man, you know exactly what she said. I was glad she did the clap back. I mean, I prefer that Congress have decorum. I really do.
Right.
But Marjorie Taylor Greene has, and
she took it there. And then the thing is, when you can't take the heat and the hell that you chose. Oh yeah. Now it's no. And like she said it so smooth though. She was like, so you mean if I say?
Oh yeah, and she did it smooth. She's like, I'm asking a question. Like I'm not calling her that. So she did so much with the rules when she did that. That's why I say it was spectacular.
Yes.
Marjorie Taylor Greene's comments were absolutely wrong. And, I get she's feeding her constituency and she's, we don't like these women of color with their big eyelashes or whatever it is.
Right.
And it's like, all right, cool. Well, I was surprised she didn't come back with the, at least I didn't cheat on my husband or something like that. But I thought she kept it. How can I say she kept it above board when she called her a bad built butch?
But she did it. She did it. I mean, you can't be mad at that, though.
I can't.
You can't. Because, I mean, even though it was a lower blow, it was done so smooth that it was just like.
Hey, look, once you cross the line, there are no lines. So.
Woo, that was a good one.
I did enjoy that.
Back to, Barbara has an actual question. So kind of like in the same spirit of your analogy, if the defendant has a history of shooting puppies, horses, and goats, we can't bring up that if the case is about drowning kittens.
No, right? I mean, well, that would be a hearing to determine, what would be you have to say what the objective is. Are you going to prove intent? Is the defendant saying it was an accidental drowning? Then you probably could. If you want to bring it up to complete the narrative. How does this complete the narrative of drowning kittens when he was shooting horses and goats? And the fact that they were being shot also already puts you on the outs because the facts are already not even similar. Other than them being animals and being killed by this person, he shot horses, puppies, and goats under different circumstances. This is drowning kittens. So unless you can find a reason to get it in there, it's not going to be intent, not going to be lack of accident, lack of mistake. It's not going to be, motive. He has a motive towards killing, animals in general. Well, that doesn't really apply because we all kill animals. If you eat meat, you are fine with somebody killing an animal in general.
Right.
So no. And if the shooting of puppies, horses, and goats, if it was done in a non-criminal manner, not going to work. I mean, for that matter, he drowns kittens and he's a hunter. Do we want to bring out that he hunts and kills deer and buffalo or whatever he's killing when he's out there hunting? Because that's pertinent to drowning kittens. It's not going to come in. And again, it also might be too prejudicial, meaning that it certainly is probative. Let's suppose that it's probative of his intent to drown the kittens. Let's go with that you get it in. In Georgia, you're probably going to get it in. Well, but let's say you get that in, but it's too prejudicial, because you got animal lovers who like, I don't think anybody should kill any animal for any reason. All right. I can't stand meat eaters. I'm like Bob Barker, I wear synthetic shoes, synthetic belts and everything else. So that might be too prejudicial. And, and especially in jury selection, you find that out, or just in general, the court might say it's just too prejudicial. Now, sometimes really prejudicial stuff comes in because the standard is not whether it's prejudicial. Because it by definition is prejudicial. It tends to make you believe something bad about the defendant. That's why you're putting it in. But the question is not whether it's prejudicial. The question is whether the prejudice that it has outweighs probative value. And if it outweighs it, it doesn't come in. They're equal or low, no. And then also the law in New York is if a different decision could be made, equally as valid, yeah, that comes in. No, it doesn't. That's not a grounds for reversal. What really comes in is, hold on, I saw the Bob Barker comment. But if the bottom line is that if it comes in and it's less than, it's all right. Comes in at the same level, it's fine. If it comes in and you say, well, it really shouldn't have come in, it's a close question. The question then becomes on appeal whether it was an abuse of discretion for the judge to admit it. Not whether, because two people can look at the same facts and each have a different opinion, and each opinion could be reasonable, and the court and the law basically acknowledges that. But if it becomes an abuse of discretion, for example, in that horse, the example of killing all the animals, if you let in all of that, yeah, that's probably going to be an abuse of discretion. You didn't have to put that in. Maybe you could have put the puppies in,
right,
or just one of them.
Okay,
assuming he'd been charged with, improperly killing horses and whatever. You just can't go into somebody's life and say, he's just a bad person. This is the bad stuff they do all the time.
Right. Yeah. And see, that's why I'm having so much trouble. I guess I don't know if I'm overthinking it, if I'm I don't even know if I'm trying to reconcile in my mind, like, what is the difference between, it's obvious. Well, no. Yeah. What is the difference between what we already know is Molineux evidence for New York and background knowledge stuff? Like, how are you, I don't know.
Background stuff will come
articulate it, but how do you separate and allow 2 days of testimony of prior bad acts, but then not allow certain stuff that was filed under Molineux?
Well, here's the thing. The relationship between the parties is always going to be relevant and probative. So when you have two people in a domestic violence situation, that's going to come into play because it does complete the narrative. If you got a history of abuse of a person and you say, I want the jury to just know about this, and that person has never called the cops before. I never called the cops. Like that. Just take your traditional, or not traditional, a stereotypical a domestic violence case. Husband slaps the wife around, gets mad, gets drunk, hits her. She never calls the cops. Finally, she's tired of it. This one day he threatens to kill her, and she's like, he was serious. She calls the police. Well, it completes the narrative, and it's so intertwined with everything. What was going on, and because how this is the first time he hit you, it's going to come in, and then again, it's up to the court's discretion. Now, the question becomes, and I think the thing that this is me humbly saying this: if you disagree with the outcome on the verdict, then you're going to go back and look at the other part and say, well, then this is what did it. This is the thing that tipped the scales. But realistically, we also have, because the court, this will be evaluated when they raise this on appeal, they're going to ask themselves this question. If it was, and somebody says completely prejudicial, no probative value, I'm going to have to disagree with Flavio for the following reason. And this is the reason. I'm not saying, as a defense lawyer, I would definitely be like arguing this right off the bat.
You're also an appellate lawyer, right?
Yeah, I do appeals as well. I would be quoting Flavio right now if I were the lawyer, like, Judge, it was completely prejudicial. There was no probative value at all. She adequately explained it. I would argue that. But putting on the middle of the road hat here, I will say this, and that is a great argument actually to make. That's actually the best argument to make. No probative value, and make them justify the probative. But anyway, as to this one, I would say when Priya asked the question, why did you not seek medical attention immediately? Well, instantaneously, all right, that's fine. But I need to tell you, because I didn't seek it because in the past, this is what occurred on that specific point. He literally said, I'll kill myself. They're going to ask questions. They won't believe you. It's going to open too many doors. So I didn't want to do that. So that's why I didn't go through that. So this time right now, when you ask me why did I do it, this is why. Because the counter argument to that would be, it didn't happen because if it did, she'd have called the cops or she'd have sought medical attention. It didn't happen because if it had, she'd have done X, Y, and Z. And so the prosecution is entitled to do that. Now, there are ways to get around that, meaning maybe you don't argue that directly on closing, but you certainly argue at the beginning. You kind of separate the points. Hey, there's certain things you expect people to do. Ask yourselves, were all the things that you would expect to be done? And then later on, go down there. Let's go through everything she did. Mm-hmm. And then you list all the stuff, but curiously, you're not going to mention the medical treatment and all that kind of stuff. And then later on, you'll be like, and then she went to the doctor 3 days later, but it's not, it's one sentence that would get you in trouble and open the door. You break it down into 3 phases of argument, one at the beginning, one in the middle, and one at the end. And you say, Judge, and now you're arguing it. So, they might want to reopen the evidence, but you say, Judge, I literally did not connect that dot. And the jury can connect whatever dots they want to connect. And I'm sure some juror is going to look at the medical records and go, well, this happened on the 1st, and you're seeing the doctor for the first time on the 12th. Whatever the dates were, what gives there? What's going on? Why the delay? So that will still be a topic of conversation. So you can kind of plant those seeds in a way in closing that tells everybody, look over there, look over there. But at the same time says, I didn't open that door, Judge. And that's the goal you want to do. But, the closer you get to the sun, sometimes, as in Icarus, your wings will melt.
Let's see, how do they separate overheard and read into gossip versus actual testimony from person didn't come down? Okay. Barbara, who are you talking about?
Well, I will say this part though, to just give you the rules of law on that point. Their hearsay is an out-of-court statement made by a witness who doesn't testify in court. It can also be your own statement that you made previously. A witness can sometimes be, they say, well, what I told him yesterday. No, in New York has a weird hearsay rule that says even what you said, you can be confronted with it as a prior inconsistent statement. It's a weird rule, but I used to object to that on that basis all the time. And people will never, I'm like, how do y'all not know this? Because it was so different from Georgia that I was like, oh, I'm going to use this to my advantage. And I really
Right.
But the point being is that an out-of-court statement by another party not brought in court to testify would be excluded as hearsay. So anybody else's other statements would not be allowed. They couldn't even mention them. You can talk about people being there. You can talk about people's reactions. You can talk about all of that, all the verbal acts. Somebody looked shocked when it happened. She was crying when it happened. You can do all of that. And you can also bring in an excited utterance as an exception to the hearsay rule. So an excited utterance would be, he punched her and Mary said, why did you punch her? Oh my God, I think he killed her. But that was stated that's an excited utterance, free from afterthought, closely connected to the actual transaction. And that would come in that way. So there are ways to get in out of court statements. But if it's not an excited utterance or anything of that nature, is not coming in, or prior inconsistent statement so that you want to confront somebody. You said X today, but at a deposition or to the police, you said Y. Then you can bring in those prior statements. But just in general, reading in gossip and all that kind of stuff, it doesn't come in. There you have that. But now,
No, go ahead. You can.
No, I was going to say on to Jonathan.
Yes, because let me just see what some of these comments. How do they like race?
When you compare the Weinstein, if you read the Weinstein decision, you'll see that one of the things, the court's very big on the fact that propensity is not. It's never allowed. We already talked about propensity, and that's why you can't introduce Molineux just to show this is kind of what you do. But they also noted that it was not a single victim crime. There were several victims in that.
Right.
So what is it? This is the brief of the that says that's their brief, But if you look at the Court of Appeals, the Court of Appeals decision, it wasn't a they made the distinction between quid pro quo, sexual assault, coerced sex from those women who were saying, oh, he told me he'd give me a job, I could act. They were like, that's quid pro quo.
Right.
While that is sexual harassment and coercive, that is not the same as without consent, or as in New York. Let me look at that because I know I used to use this. It's not the same as force. Like force, or New York's language is forcible compulsion. So it's not it's not forcible compulsion to say, hey, if you want a job and you want X, Y, and Z, or I'll put you in contact. You got to, the casting couch is right over here. It's not that. That's not the same as forcible compulsion.
Right.
So that was one of the distinctions. So there were also some factual dissimilarities, and that's important. And the court kind of focused on it. These things are just dissimilar. Casting couch and the women in the Weinstein case had, many of them, I think all of them may have had ongoing or had at one point had sexual relationships with him or romantic relationships with him. And then were like, no. And he overrode their will, or they claim he overrode their will and forcibly had sex or forcibly groped them. That's different than somebody saying, he told me I would never work in this town again unless. It's like, all right, that's not the same. So the court looked at that. And if you just have a one witness case, sometimes that may tend to make the make it more probative than prejudicial. Meaning now we want to introduce this because I got one witness. You know what I mean? And I once had a case. I'm not even sure if I got it in, or at least I was going to get it in. Where when I was a prosecutor in New York, where the victim was a crack addicted prostitute in a rape case, and I was going to bring in some other stuff that he did, but I had to get it in. I'm like, I got to bring out the other stuff he did, Judge, because it goes to prove intent. It goes to prove, all whatever the Molineux arguments I made at the time. But I also really needed it because I had a crack addicted prostitute, who says that this rape happened on a sidewalk. It's like, come on, but it actually did. And he beat her up too. So it came in this. So in the Jabari Majors matter, with one witness, the court on appeal might look at it and kind of go, well, because this is a one witness situation and it had an ongoing matter, and because you asked that question, this is not an this was properly admitted by the court after you opened the door. It was properly excluded, and then you opened the door and it was properly admitted. And that's really where the problem lies is once when you open the door, you open the door to a lot. It's like, well, you did it. You can't complain. The general theory being, you can't induce an error and then complain about the error that you induced. Except, in law, if your lawyer does it, you have a claim for, ineffective assistance of counsel. But that standard is still high because we still go back to, was it prejudicial? Was the conduct deficient? If it was deficient, was it prejudicial? And if it was prejudicial, was it so prejudicial as to affect, was it harmless, or was it so prejudicial that he gets a new trial? And this question, and if it's just like, well, here are his words and what he said to me on a previous event, and given everything that came in, do I think that was it unduly prejudicial? No. And you kind of induced it. So that's the tolerances or the space, if you will, is much narrower there. So whereas with Weinstein, the court was like, no, come on, y'all just had 3 unrelated women with dissimilar facts.
Just coming in here, right.
You just trashed this guy and then said, there, he's guilty. On this one, it's like, that's different. If it had been some other woman and they said, well, we not get to bring in Mary Jane to say that he threatened to kill himself because I was going to tell the police what happened when I went to the hospital. Now it's like, well, who's Mary Jane? Why is that relevant? That has no bearing on why this woman didn't call the police at all. Zero. So,
but you do know that, the day of the original sentencing day was in February.
Right.
And when it was postponed due to the motion to set aside verdict and another motion, I think, to keep that other Molineux evidence sealed, they postponed it to April. Right. And so the same day that the original sentencing date was postponed, all that Molineux evidence that was not released during trial somehow got leaked to the media. And it was a couple of other exes. You understand what I'm saying?
Well, I had heard about stuff beforehand, but I do get, but the question becomes who leaked it and why.
Well, we know who. The question is how.
Well, also whether the jury heard about it. That would be a good issue.
That was after sentence. I mean, after the trial, this is what happened.
That's right. No, after sentencing. So if it didn't come out, yeah. I mean, it was going to come out anyway. So let's go like this. You got to figure out how you deal with it once it does come out. You and I have talked, off camera about my very clear standards of how to bounce back from this. I have a very clear plan that I think works.
I will relay the plan.
They relay the plan. Tell them to call me. I'll break it down for them.
Yeah.
I'll give them 10 minutes for free.
Okay, no, I'll tell them. I'm serious. I mean, we got to do something. All right, we have a question from Barbara again. During the appeal, will they be able to bring up the fact? Yeah, because remember, there's a whole list of different. We were saying that he's not going to just appeal on one issue. So let's just say, for the sake of argument, Molineux is something that he can throw out there. That's not going to be the bread and butter. That's just something to just add into the mix of several other things, like all that background information having more prejudicial than probative value, like something like this. But I think, if I'm not mistaken, Kirby, is the reason why his injuries were not allowed, in addition to when Jabari's arresting officer took the stand, they objected to almost everything. He testified to virtually nothing because everything he tried to testify to was objected to and sustained. Is that because Jonathan did not testify that they could not open the door to the injury photos because the jury never saw those photos? They would show them to people on a stand, but the jury couldn't see it.
Right, but now these injuries were injuries that were occurred to him during this time. See, I didn't really understand.
Scratched and skin was ripped off his forearm right here and his face, and then obviously his pocket was torn on his coat, torn off basically, and then some of the buttons were torn off of his.
I think that I don't know why I don't remember why the judge didn't allow those in.
It's not even about remembering because they didn't say. Not that I recall. I just remember them showing different witnesses the pictures, but they made sure that the jury couldn't see them. I could see them from the audience because when they would pass them, I'm sitting behind them. So I can
clearly
see that it was the face and the arm injury.
But I would say this on that. I think a good argument would be that certainly that they should have come in, especially the torn pockets, because when the jury is trying to evaluate how her fingers were damaged or anything of that nature, I think it's important to show, like they heard evidence of the scratching and whatever, but I don't think it was self-serving. As long as those photos were authenticated properly, this photo was taken at this time on this date and fairly accurate depicts what was, if they laid the proper foundation, I don't think they necessarily should have been excluded. And in this instance, where the evidence was less than overwhelming, and you want to argue the introduction of these photos could have explained how she obtained those injuries. I mean, if his pocket is torn off and she's like, well, he broke my fingers in the car, or let's look at that jacket and let me see how that jacket looks, because the amount of force, because I'm just telling you, I'm actually, and it sounds bragging, but it's, I was a former Division I athlete, but I also say that I was a discus thrower and shot putter. But let me say this: you ever try to tear some clothes? That is not easy to do. It's
not easy to do, and I'm positive that's how she injured her finger.
All right, and that's what I'm saying. So I would like to show. Let's describe the clothing. Let the jury see this right here, because it to me would sort of have denied the jury the ability to properly evaluate the that harm and to correlate it to that damage. And because again, nobody really said when it happened. And we're like, well, it could have happened here. It could have there's a bunch of could have happened here.
They clearly indicated when his injuries occurred, because she admitted to tearing the jacket. That's the crazy part about it. And they did establish all the metadata. That was the first witness on the stand. Before she got on the stand, they put the prosecution's data digital analyst on the stand, some young kid, probably 21, 22 years old. And they actually spent a good 45 minutes to an hour going through all the pictures that they were going to be presenting as evidence and asking him to confirm the metadata on those pictures, because they were all taken with iPhones. So with the iPhone, you can see date, time, location, what lens was used, what exposure was used, everything. And he sat there picture by picture. Of course, certain ones he played like he didn't know. And of course, it was the ones of Jonathan's injuries. He pretended like he couldn't convert Pacific time to Eastern time and yada, yada, yada. But it was clearly established that every single one of the pictures being presented by both prosecution and defense had metadata attached to them that can prove when the picture was taken, where it was taken.
And that's why I'm saying that I don't even know that I get the objection and that's technical, but I would also say it didn't really matter to me where it was taken. As long as it's the jacket, you know what I'm saying? Like if you hit my car and then I go take a picture of it at the garage, and you're like, well, you didn't take it at the scene. Well, as long as I can authenticate and make up the gaps that there was no damage to the car from the scene to the house and all that, and that should, any objections like that should go to the weight. You know, he could have hit it. He could have done some more damage. Yeah, he could have, but that's for you all to decide. But I think that might be good. And who knows? Hey, maybe they could have brought in, and now my brain is tricking my undiagnosed but diagnosed by my now college graduate daughter ADHD is that somebody, maybe they should have taken that jacket and got a similar jacket and had it. Because let me give you a background. In firearms cases where people try to claim that it was an accidental discharge of the gun, they will literally do a trigger pull test to say it takes so many pounds of pressure.
How many pounds of force, right?
To pull that trigger. Maybe you get that jacket. Maybe you get somebody to say, well, we had to look at how much force it took to, we got the similar jacket. We also tested the fabric on this one and the thread. And we go. Somebody says Grace Torrey's jacket in the car, which is the perfect place for her to have broken her fingers.
And she admitted that. And then you also see outside the car at least twice that he's ripping away from her when she's grabbing him. That's another time that you could have hurt your finger.
And that's what I'm saying. And she just, Daisy Ball is absolutely correct. It is definitely hard to tear denim.
Oh, yeah.
And I have absolutely tried to tear it because I was like, I had some old jeans, but I'm like, I'll just tear these. You probably get a little bit, getting started is hard. Once you get it going and it starts going, then you can work.
Yeah, but you got to get started.
And that getting started is not easy. And so I think that something like that could have been done to say it takes 50 pounds of pressure to tear this, or 20 pounds of whatever the pressure is. And now you got some other thing. That's just me playing armchair quarterback. I don't know if there was enough to go with that, but that's an angle that comes to me right now as we sit here. You're seeing my brain work. So if you see my eyes darting back and forth, it's because I'm seeing it in my head that's kind of an angle, but it's an unusual thing. I don't think anybody's ever done it before, but that would be something that you certainly could consider. Right,
exactly. And then this is just the Officer Mejia that arrested Jabari for essentially the same crimes, but she was not charged or obviously indicted on any of that. When he got up there, they objected to everything. The only thing he could testify to is how he ended up filing the incident report that led to her arrest. Anything else in between, he was not able to discuss. Okay. So that's something else that can probably be brought up on appeal, and
yeah, no, absolutely. All the exclusions of witnesses, all that stuff is absolutely what you have to go with, because you got to be able to say that the jury gets to hear it. And obviously, if he gets a new trial because of those things, then you can say you might win on the new trial, or the prosecution might say, you know what, we're done. I mean, I'm sure they might want to invest with it. They spent so much money on that case. I don't know if they want to spend it again, but who knows, they might. Oh, and let me just go back on something on the Weinstein case and Edwards and Majors. There's another case out there that's called Sandoval. And the reason I mention that, because when you're reading Molineux and Sandoval are two different things. Molineux is the crimes to show for the limited purpose of the statute that you showed. Sandoval is stuff that affects your credibility that they can introduce. It's not Molineux stuff. It's things they can cross-examine you about if you take the stand. But Sandoval comes in when you take the stand. But if you never testify, you got to worry about it. But in Weinstein, they were saying that the stuff that they were going to admit is what discouraged him from taking the stand. I don't know that there was any Sandoval evidence that was going to be, I didn't look and see what Sandoval evidence was sought, that the prosecution would have sought to admit against Jonathan Majors. Because if they sought to admit some Sandoval evidence that they wanted to cross-examine him about, should he take the stand as it related to his credibility, and it was improperly allowed, and he then chose not to testify because he didn't have to go through that, then at that point, that would also be a basis. So he's got two areas to mind. I just don't remember from the trial if they said that.
Say that again. If
they said if Mr. Majors were to testify, I'll allow you to ask him about X.
No, not that I recall. Like I said, I missed one day, so I don't know if all that happened that one day. I didn't go, but while I was there was never any talk of his testifying.
Well, then I think what they would have done is it would have happened pre-trial. So at the same time, that they were doing the Molineux, they would have done the Sandoval.
Okay, gotcha.
So if you don't recall hearing the Sandoval.
So, yeah.
And then as to Daisy's question, the 2 precincts that found probable cause after investigation and arrest her for assaulting him and stealing things of value, but choosing not to, that is the system. People get prosecuted. I will tell you something, and I just a brief pause. I know we're talking about this, but years ago, they did a study in Florida, where you are now, that assessed sentencing, that evaluated all the sentences that have been handed out to defendants, and they were doing an apples to apples comparison. You got 2 priors. We're going to compare that to another guy who had 2 priors, and they were doing, comparing whites and blacks and the like. And they found that just the treatment of 2 similarly situated defendants charged with the same crime with the same background, they were just sentenced disparately, and it happened along racial lines. Now we got all this AI technology, and I notice that nobody's doing it, but somebody ought to be going through and evaluating and running, the stuff through the system to just see, like, hey, we're going to put on the sentencing sheets and all the background information that the court was informed. We can run that, and we can find out, what the disparate things are. So when you talk about this, them charging him and not going after her, that happens all the time.
Well, yeah, because you said too, it has to do with that whole
retaliatory.
Yeah, and that what was it? Is it the Fifth Amendment? Was it the Fifth Amendment?
No, there was just no reason for them not to do it. I mean, I'm just telling you. The reason, I'll tell you why they didn't do it, is because this is what would happen. If she's facing charges and you're going to prosecute her for that other crime, then she has to decide whether she's going to take the Fifth Amendment. And
that's what I was. I knew it had something to do with the Fifth Amendment.
Exactly. So if you don't want Fifth Amendment, you both got the Fifth Amendment, you're both being prosecuted. Y'all want to talk? Nah, I don't want to testify at all. Okay, the case goes away. Now I can see you dropping one versus the other. If I slapped him, he shot me. Okay, we're not going to prosecute you for slapping somebody. We definitely going to prosecute somebody for shooting you. Then you kind of go, well, you went after the more serious crime, and I get that. But when you got crimes of the same level like this, and they just flat out said, we ain't got to look at your stuff, that's a problem. And they gave her that benefit, and they protected her Fifth Amendment rights, and they made a decision to go after him. And that may have been because the prosecution was aware of those prior incidents that you said that came out after the fact. They could have just simply said, you know what? Our prosecutorial decision can be based on everything we know. And we've talked to 5 women or 2 women or 1 woman who told us this is what he does, this is what he did. And we found all this background information out. And we're prosecuting him because this is what he does. And that's just, they can make that decision, and it happens all the time. I'm not saying that's what he does. I'm just saying that that's how they would go through it. And you'd be like, well, he had 2 girlfriends that say this happened in the past, and she told us that it's gone through several times, and we look at these text messages, and she said, all right, cool. You know what? We're not going to prosecute you. Even though you admit to doing what you did, that's all right. And
you know what I think made, because I know it was leaked, and I'm positive it was leaked by somebody in the DA's office, but we're going to pretend like that never happens.
Right.
I think the reason why, because when the other 2 were revealed literally the same day that his original sentencing was postponed, we very quickly, I don't know if anybody else, because as soon as I saw the names, I researched. I think I sent the information to you. As soon as I saw the names, I looked them up and I did my, spy gadget stuff, and I found them. Found the Instagram page of one of them. Same day, posted some cryptic poem, and then in the caption tags the other one saying that she loved her deeply. So now the 2 exes are now best friends that love each other deeply. So I feel like I wasn't the only one that did that. And that's why I didn't really get any traction, because almost as soon as the New York Times and Rolling Stone released that, the other 2,
right,
it went away. Because you kind of see what it was now. Okay, now did this really happen? Or are these 2 people getting together? You know what I mean? trying to, and then one of them, now she instead of going by the name that she went by when she interviewed with whoever, I guess the New York Times originally, she now goes by her middle name, which just happens to be the name of Jabari. Her, I'm not going to name her, but let's say her name was Jane Doe when she interviewed with the media outlet.
Okay.
Now her name is Jane Grace Doe.
I got you.
Her name is Jane Grace Doe on all her social media, and she's the one that the last real girlfriend before Jabari says that she loved deeply after posting this cryptic poem on the same exact day that this article was released, the same exact day that his sentencing was postponed.
Okay, I got you.
Chill. I literally said I said I'm not going to say the name, and Chillmonger puts the name in the chat. I'm not playing with you today. You Google it, Chill, and you'll see exactly what I'm talking about, because that's the person that did what I'm saying that they did, and tag Jane Grace Doe in it. Then, my Spidey senses / conspiracy theorist went further down the rabbit hole, and it turns out that Jane Grace Doe is married to a former SNL, one of the comedians, because they switch out comedians like underwear. She's married to one of them who was on the show at the same time Jonathan did his episode.
Which was a great episode, by the way.
Yeah, but that guy that she married was working on that show, that same episode. So I'm almost wondering now, did she say, "Oh, he's going to be on the show"? You know what I'm saying?
I got you.
It just seems like a whole. I don't know if Daisy. I don't know if he needs to delete the name because it's public record. I just wasn't saying anything because I personally don't believe in giving clout to clout chasers. But if you Google, you can find them. I found them within 5 minutes. You
are an amazing investigator, because I'd have been like, "What?"
I found them within 5 minutes, and then I was able to find the Instagram and all the tags and everything else.
Right.
But Earl wants to know if Major's appeal. Well, the thing is, okay, before you even answer that, and I did send you that, Kirby. He had obviously 30 days to file his counter claim to her civil. He was granted an extension, which was agreed upon by her Florida-based. They have a New York office, but they're predominantly based in Tampa and the Miami area.
Okay.
Personal injury attorney. He sat with Jonathan's, well, not sat with, but communicated with Jonathan's attorney, and they both agreed that he had until mid-July to file his counter to her civil. Right. So that's the first point to make. So I don't know if his appeal. I'm still trying to figure, because I could have swore that the timeline ran out on that too, the appeal. Because once they confirmed the sentence, which should have been happening because the sentence was April 7th, I don't think it takes more than a couple of weeks for them to confirm the sentence. That's when the clock starts.
Well, I'll answer the question this way.
Appeal, huh?
It doesn't affect the civil and the criminal are not impacted by each other. The criminal conviction, and think of it this way, there are two different burdens of proof. Civil is preponderance of the evidence. Mm-hmm. Criminal is beyond a reasonable doubt.
Right.
It's two different juries, two different fact finders, two different things. If you plead guilty, you are admitting it, and that constitutes a declaration against interest. So if he were to have pled guilty and then filed a counterclaim that undercut that guilty plea, well, he'd be kind of done. Mm-hmm. If he's asking that question. As far as her civil suit is concerned, even if he wins his appeal, or her civil case is not in any way dependent upon her winning her appeal. I mean, him winning his appeal, meaning if he wins his appeal, doesn't impact the civil case. They can still go forward. If he loses his appeal, it doesn't mean that he doesn't have a defense to the civil case. She's still got to prove that civil case. So no, it will not impact it at all.
Right. And then, like Barbara says, it didn't stop Ron Goldman, because that's the thing. You can win or lose criminally, and then turn around and the opposite will happen civilly.
I've seen that. I've seen families sue for murder. At the end of the day, it doesn't matter. The two are just two different things. It's like what you do in the kitchen isn't what you do in the bedroom. I mean,
sometimes it is.
Well, that's what I'm saying. I was actually about to go there, because sometimes you may do this. Yeah, exactly. You do the same thing. You might start in the kitchen and finish in the bedroom, or start in the bedroom and finish in the kitchen, or whatever. Right. But the bottom line is, the same thing is happening in both places. But because you didn't do it in the bedroom doesn't mean you can't do it in the kitchen. And because you didn't do it in the kitchen doesn't, the two are just, they're connected by event and transaction and everything else, but that's it. The two are separate. If he got found not guilty, as was pointed out there, OJ.
Yeah, but he was found criminally responsible, civilly responsible for her death. Which still to me doesn't make any sense. I personally believe he was guilty. Rest in peace, I guess. But I still don't get how, if you're not guilty of a crime, how can you be guilty of contributing to the crime? Or you're not guilty.
That's because civil, you're not. In criminal cases, and I learned this, and I'm going to take you through history. Remember when Mike Tyson got charged and they said, how do you plead? He said, innocent. I once had a client that wanted to do that same thing, innocent. The judge ripped him a new one. In criminal law, you are never found innocent. You're just found not guilty. Your options are guilty or not guilty. So they say not guilty. That doesn't mean you're innocent. It just meant that the state failed to prove your guilt beyond a reasonable doubt, which is the highest standard that we have. In a civil case, you're not found guilty at all. That's not even an issue. The question is, are you liable? Civil cases, think of it this way. You go to the old stores, you go to a curio shop and they have a sign, you break it, you bought it.
Right.
You break it means you're liable. You did the act that violated some rules, so you're liable. You bought it, that's the damages. In a civil case, they can say, hey, we couldn't prove in a criminal case that he killed her, but that never comes in a civil case. They will still introduce all the facts, and the question becomes, to a preponderance of the evidence, 51% to 49, 51 to 49, do you tip the scales just a little bit in favor of the prevailing party? And if you do, they broke it. They are liable. Now let's go to damages, and then it's about how much you pay. So whereas in criminal, there's no balancing. It's just the prosecution bears the burden. You got to bring everything necessary to prove this person's guilt. So they're just two different standards, two different rules. It's just so different. They both happen in a courtroom, and that's about it. Involving judges and a lawyer.
So let's get off the appeal for a minute, because that's stressing me out. I'm already overstimmy. So from the civil, I'm feeling confident that, assuming that once in July, once she sees what their civil suit, the grounds for their counter is or are, she kind of just says, all right, I'm gonna leave it alone. Because the likelihood of me losing is probably higher than winning. Especially because in a civil, we can bring up the fact that you got arrested too. We could bring up the fact that you scratched me, you ripped my pocket, you ripped the buttons off my jacket. We can bring up the fact that you called me 32 times and text me, I don't even know how many more. We can bring up the fact that you faked like you died. We can bring up the fact that you took my Rolex and my iPhone.
Well, that's what I'm saying. No, not all of that comes in, because that same evidence code still applies. So is it probative? Is it probative? Is it relevant? That is, it tends to prove a fact. Is it probative, which therefore makes it relevant? And then you can still have that prejudicial argument to keep stuff out, even in civil cases. And it has to be pertinent to the issues at hand. We're not going to
go right. He would have to, before bringing any of that stuff out, he would have to say, okay, well, she did this, and then this is the stuff she did with that. Then she stole this. This is how she stole my Rolex. I asked for the iPhone back. She didn't give it back. And then she did this. She was harassing me. She called me 32 times. She texted me this number of times. She faked like she was dead in my closet.
All of that could be pertinent in a lawsuit, provided it was I still go back to probative. It's got to be probative and therefore relevant to a fact at issue in the trial. And we're not going to just let you trash somebody for everything they ever done.
Right.
I mean, you can get a lot in there though, because the issues are a little different. Whereas in criminal, the issues are about making sure the defendant had a fair trial and their constitutional rights, and a lot of other issues that are involved. In a civil case, you do have more room to do a lot of things, but you still have those issues of probity, relevance, prejudicial, whether it's collateral, like the fact that she stole your Rolex has no bearing on the fact that she hit you in the face in the car that day. So
I would file that under like because I use the word harassment in layman's terms, like you're harassing me, like stop calling me, stop.
I got you.
Come to my house, stop. That's my, so I'm just using harassment in that context. Oh, no, but for example, during her victim impact statement, she said, "I will not rest until he cannot." What did she say? I will not rest until he cannot hurt anyone else or something like that. And to me, that stood out because I'm just like, okay, this is done. What are you going to do to not rest? Like, are you going to keep using the courts to harass this dude? Or are you going to start saying things or doing things to keep him in a negative news cycle? So I'm like, that to me, I like I said in my last stream, if she would have said, "I will not rest as an advocate in support of women, domestic violence survivors," that's different, because you're generalizing that now you're going to be a spokesperson or poster child or whatever against, intimate partner violence. But she specified him. She said, "I will not rest until he cannot do this to someone else." So I'm like, what else can you possibly do? And that just kind of gave me pause and gave me the impression that she's just going to keep trying to do things or say things or pull rabbits out of her hat to just keep him in this vice grip of not being able to get rid of her.
I will say this. She has the bully pulpit in this one because of the following. No one is ever really going to trash an alleged victim of domestic violence.
Well, they're not feeling her. They're not feeling her at all.
No, people aren't feeling her, but see, she's not saying me. She's like, "I'm stopping you because you're evil, and I'm doing all this because you're evil, and I'm protecting other people from you." And unlike like Amber Heard, if you watch how that case went, for a while it was wildly anti-Johnny Depp. Oh, he's horrible. He's terrible. I can't believe he's going to lose the Pirates. All of that stuff. And then they started bringing in stuff about her, and then she was just kind of like a psychopath on the stand and all this, and then suddenly the tide turned. So if the tide can turn against Miss Jabari in a civil case, then she loses a lot of momentum. And the only way the tide is going to turn is by bringing up all of those things and having her to answer the questions that she didn't have to answer in the criminal case. And so then the tide can turn. So there are ways, I mean, and people can ask her questions at the times when she's in an interview. Well, what about that? How much force did it take to tear a jacket? Are you can start going through all of those things. And the reason that it happens, or what will happen is, there probably won't be a coherent or consistent answer given. And the more different answers you get, the more people begin to go, wait a minute. And then also, the more admissions that she makes, and especially if they were to do the whole fabric tear test, it would be great if they come out and they go, you know what? The fabric tear test, is what changed the Americans. And I'll be like, yeah, it was Kirby Clements on Daddy's show.
Right. Just like the glove don't fit, you must have quit. We're going to use the fabric tear test. But I think there are several instances that she did. I don't. Is it impeach or perjured? I thought it was perjured.
Well, impeach is when somebody brings out facts that tend to undermine you. Perjury is when they prove that you lied.
Right. So she did both.
Right.
I mean, now I'm saying that it was quite obvious during the trial too that she was not telling the full truth. And to me, a lie by omission is still a lie. And she did say that during the victim impact statement as well. She said that the lawyer kept calling her a liar. You cannot sue him for something his lawyer said, but we'll pretend like you can. She said that they had her looking like an alcoholic. No, that was your expert witness from Bellevue Hospital that said that you failed that audit C test 3 times over the course of 2 hours. That's who called you the alcoholic clinically. She was just rambling on and on and on. And she said that he thinks he's above the law, like Daisy says. And I'm just like, how so? What did he say or do that indicated that he was above the law? He's the one that called the police because you pretended like you were pushing up daisies in his closet after being on the phone 13 minutes prior, texting your bestie.
Plus, he didn't resist the police. And I'll be honest with you, people who think they're above the law,
they resist the police.
They just do. What are you doing? Right. Get your hands off of me. There is a clear pattern to above the law. Now,
right. Or he wouldn't have called the police at all.
Yeah.
He would have just backed slowly out of the apartment and went about his day.
And shoot, a true above the law guy, he would have put her out of his apartment. You got to get out of here. I don't know what your problem is, but you can't have it here. Because
get up and get out. Right. Exactly. So, and when I say perjured and or impeached, I'm saying based on what her civil complaint says in comparison to what she testified to. I'm like, if all this happened, why didn't you say that when you had the opportunity? Because none of that was Molineux evidence at that point. So, for example, and I'm not going to go into every single because it was a whole laundry list of background information. Right. But for example, there was an incident that was testified to and that he admitted to on the Good Morning American interview where he smacked some candles off of an end table. And she actually, as part of the evidence, there was a photo of just the candles broken up against the wall. You couldn't tell when or where it happened. She testified about the incident that led up to it, but it was just a picture that she took of the stuff broken on the floor. He admitted to that. He said he did that. He's ashamed. He would not want his child to do the same thing or engage in that type of behavior. She left it at that. She explained sort of what led up to he had come home from work. He was working on the movie where he played the bodybuilder. That's Magazine Dreams that has not been released. He came home. He was a little irate. It got to the point where he slapped the stuff off the table and it broke. But that was where she left it for the most part. And the civil complaint, she goes into details of how he did this, he threw her, he did this. So I'm like, why didn't you say that during the trial when you had the chance?
Well, it may not have been admissible and it may not have been pertinent at the time and she just couldn't volunteer it. It's up to the prosecution to ask that question. So if the prosecution chooses not to ask
I'll send you the transcript because I feel like they did. I can't, it's hundreds, if not thousands of pages of transcript.
Oh, no, I got you. But again, here's the thing. The beauty of that, this is the same reason I tell people don't talk to the police, is this. Anything she didn't say and the argument that you just made will become the cross-examination questions during the civil case.
Right.
During the deposition. It's like, hey, they didn't ask me that right here. They just hit that question. This is what you were asking. This is your answer. You omitted that. Well, I didn't think I was supposed to say it. Anybody tell you not to say it? No. So you just omitted it on purpose. Or is it because it didn't happen? And that's going to happen over and over again. Mm-hmm. And so I
feel like she lied by omission though, because when she recounted what happened in London, she got into way more detail. Oh, he stomped on my AirPods. He yelled in my face. He did this. He did that. okay, why didn't you say you understand what I'm saying? I think she picked and chose what she wanted to elaborate on and then decided in the civil suit to just give it wings and colors.
Or you have to ask yourself this, though, because a jury, if it gets to that point, will ultimately be responsible for making a decision. And they're going to basically have to decide, do we think that she just lied about everything? Like lie by omission? Because the counter is he didn't stomp on her iPods or AirPods, whatever the heck it is. You know, he didn't stomp on it. He didn't hit you. He didn't do that. None of you made up all of this, or it was all mutual combat, but it's going to have to be that. And that's why the scales 51 to 49, if she's like, this is what he did, this is what he does, and this is how he did it to me, and you say, well, you lied about this, you lied about that, so it didn't happen. A jury of people that don't know them are going to have to sit there and go, do we think she made all of this up?
Or, like I said, it's lying by omission, because at the end of the day, obviously some of the stuff happened, but did it happen that way? Or
that's the point, though. As long as it happened in a way to give rise to liability. I mean, that's where you always say you never can tell with a jury trial. But it's like, how did it happen? How did you do it? What, do we think that it just absolutely did not happen? Or if you say lie by omission, it's like, or is it just, I answered the question at the time, I was nervous, I gave you what I got, I gave you the meat. I mean, what really does that add to it? I mean, so you got to really think about, just take a story, somebody tells you one thing and they tell you something in a little more detail, and you're going to be like, aha, nothing happened because you added some new details that you didn't tell me before, so you're lying. Or you're going to be like, okay, we need to work on your storytelling skills, because right now I'm struggling with some things. And
because my thing is, how do you, did I send you that civil suit?
I don't know.
I don't want to repeat a lot of the stuff because it's really some serious, there's some serious allegations in there. But I mean, how do you forget that level of violence against you that you're alleging? You don't forget that. That's why I'm just like, so it didn't occur to you to mention that when you were talking about this. That's what I'm saying. Everything in the civil suit she testified to, except she didn't get into the level of detail as she did in the civil suit.
And I'm going to say this. Like, I will say the following to you. It's important
to know that he did this, and this.
Oh, absolutely agreed. And you're pointing out all the stuff that is what makes for a great trial. Again, another great trial or a great civil case. I will say, not that I'm trying to play devil's advocate to your passionate advocacy, but I will say this. When I was a prosecutor in New York, sex crime, I tried a man for rape of his wife because his wife, when the case came in, it went to the domestic violence unit because she just complained about him beating, about him, slamming her head on the table. And they were like, oh yeah. But then when she called the police, she told me hit me on the table and knocked me out. And they were like, okay. And then she went to that whole police interview. And then when it got to the domestic violence unit, when the lawyers there were talking to her, they ultimately, when she's going through the story in more details, they're asking her all these questions. Then what happened and what happened next? They come to find out when he knocked her out on the dress, he picked her up and slammed her down on the bed, and she had her head on the back of her head on the nightstand. She was unconscious, and she woke up and he was having sex with her. And from her cultural perspective, at least what she testified to, she said, in my culture where I'm from, because she was from another country, she says a husband cannot rape his wife. That's unheard of where we're from. Right. So how did she leave out that she was raped? And they went to trial with me. We offered them a great deal, basically better than what Jonathan Majors got. We offered him like a B misdemeanor. And the defendant said no. He did one of these numbers like this. He said, tell him no. I didn't want to offer him a deal at all. But my bosses did. So I said, I will offer him a deal. He gave me the backhand and he was very arrogant. He said, no. Yeah. Click like that. And I was like, oh, it's on, baby. And that man's probably still in jail to this day. I don't even know. I mean, I don't even care. But the point being, but they tried to ask the question, how did you leave all that out? And it just comes from, again, a lot of the high points in my mind that got left out. So there are different ways. And then the lady who just posted, that number 45 has trashed all of his victims. Yes. And if you have any, I tell everybody, the prosecution gets to put all this stuff out in the news. The Jonathan Majors had all this news coverage and this stuff, but it was all really pro-prosecution. You know what I mean? So sometimes you got to have somebody out there to trash the victim or to trash the police or to stir up some mud to just say it's not as clean as they're making it seem. And I have to know from a case I'm involved in, the police just flat out lied and the press was just putting it out there. And I'm like, that's not even true. I know it's not true. I'm reading the stuff, but so you got to have that. So he had an uphill battle, which now that they're going through the civil stuff, if he could be vindicated in the civil case. Hey,
and I pray he is.
Because at that point, you got two different narratives. You got, it's a different burden of proof. We proved it, yeah, but you proved it when all the evidence wasn't allowed in. And now that the stuff that they kept out over there gets to come in, then it happens. Barbara Offenhope, if you drop off the word British and put an E on blonde,
yes,
I tell people all the time, I know
that built blonde British tears matter.
Yeah, it was that bad body blonde British whatever. That's what she should have said to her, and then be like, "Shed your tears."
Right, exactly.
But so the civil case, also there's a thing you mentioned. There is litigation immunity as well, meaning what you say in court, we're not going to let you file a lawsuit about what was said in court, because then we just have lawsuits, endless lawsuits, begatting new lawsuits. What you said, and you can't do
her or him?
No, any of them in this case. But the statements that were made outside of court are not covered by litigation immunity. So, but all the statements made by any party can be used as prior inconsistent statements. So the things that you've gone through by her omitting those things, if her story gets more and more and more egregious for him as time goes on, to me, it's like wonderful, because you know what? If those facts were true, he'd have been charged with a felony and we wouldn't be talking about this today. So you didn't tell the DA that, you didn't tell the police that, you didn't tell it in court. And so you got a litany. The more that somebody says that was not introduced, and the more so, then it works in his favor, in my opinion, because as you said, it's like, wait a minute, like you think she absolutely lied. I can just go, well, lied, fabricated, it's getting bigger and bigger. Really what happened wasn't even that. And then so he has it. But see,
that's the strongest basis of her civil suit, is that they made her out to be a liar. So that's why she's trying to sue for defamation as well.
In court or out of court?
The civil suit that she filed.
No, I'm saying they made her to be a liar in court, and they made her to be a liar out of court.
Both. She's saying that the lawyer, because the lawyer did say in her closing arguments that it was little lies, big lies, white lies. That was like she was spitting bars during the the closing argument. That's
all permissible. So that's going to get bounced out.
And then how are you suing him for something his lawyer said? He didn't say it.
Well, the lawyer,
she's not suing the lawyer. She's suing him because the lawyer called her a liar.
In court, which is what I would call you in court, and sue me in court. Yeah, no, that's going to get kicked.
And then she's trying to say that it was defamation because during the ABC 2020, not 2020, Lord, I'm all on the wrong TV show, Good Morning America interview, she literally quote by quote goes down basically the whole interview of what he said, and he didn't say anything other than, if he could do it again, he would not have picked her up and put her in the car. He would have just left. He would have let her keep the phone and bounce.
See, that's what I'm saying. So she might have done herself wrong, unless New York has some rule that statements made in court can be sued over. Most places have litigation immunity.
I think she's just pulling at straws, because when she went and did almost the whole damn transcript of the Good Morning America interview, I'm like, where did he say that was defamatory? What?
No. I think that's
that
fine.
He did not cause your injury, because they did make a point to say that. That's not defamation. That's his opinion.
Well, no, because that's what Donald Trump got hit for by that woman. I don't know her name, where he said he didn't. Not Stormy, the other lady. Where he said she's not my type, and they said that was defamation I don't know how. I actually don't know how that's going to stand.
I don't even like Trump, but what? So you can't have a type now?
Well, I mean, I guess because they were saying because she looked like one of his ex-wives, and I don't know which one she looked like, but all I know is that New York seems to be a place where now if you deny that you did something, people are suing you for defamation. Even if the statute of limitations is passed, I've seen a lot of lawsuits along those lines of, well, you said it didn't happen, and so that defames me. And it's like, hey, I don't know what am I supposed to sit there and say it did happen? That's stupid. So I don't know. I find that a very troubling development in law in general.
Yeah, that's insane, because that means you have to sit there and basically just self-incriminate and say you did something you did not do so that you don't get sued for saying you didn't do it. Yeah,
exactly. It's very disturbing. It's very distressing to me.
Yeah, like what? Like that, where do we do that at? I'm confused. So I'm just supposed to just say I did something just so you won't sue me.
Right, exactly. Or you said, these things, they did defame me. People started saying, I was like, hey, I can't help how crazy people act towards you. That had nothing to do with me. But we'll see what happens. I just find that those lawsuits.
Oh, and then she also said that even though probably the same number of people were in her comments or in the comments of many other gossip blogs dragging him down to the white meat, he's suing him because she claims that he hired everybody that defended him to go after her in her social media. Do you not realize what social media is? It's literally social media. People from around the world, if they know who you are, they can find your public profile, because her profile is public on Instagram. And at the time, her comments were open. And if they decide they don't like you, they will go and say that under that post. That has nothing to do with him.
Yeah. I am a frequent. I sometimes jump in there just to see if I get things started sometimes. I'm not a troll, but I will post some comments and people will come in after me. And I'm like, hey man, look, I'm just in it for the fight, for the battle. But yeah, I get that. But no, she has no claim. I don't think there's anything.
Yeah, like how do you claim and how do we track who's connected to him and who's not? Out of hundreds of millions of people on countless social media blogs, like all the the shade.
Plus, you've been on the news. You've been on the news broadcast. Literally, you have gone on a tour, and then you claim people were targeting me because
of him. He actually sat there and called up people and said, "Look, get on there and start harassing her on social media." What? So I guess he can say the same thing then, because I think more people were harassing him and saying crazy stuff about him than they were about her.
Oh yeah, no. If you go out on social media, I actually don't think, unless they come, as long as somebody doesn't engage in bullying, I think
they do though. You know that though.
Well, no. I mean, not bullying, stalking.
Oh, stalking. But they'll definitely say bullying.
But in terms of just going on there, if you got social media, say, hey, look, every time this person comes on, you go on there and you just disagree and trash talk them and all that, and people are like, man, that's as long as you don't break some crime. Commit a crime, right? That's the nature of social media. It's the place you go. It's the place you go to get beat up or to beat up somebody. I mean, that's literally that's what it has descended into. It used to be you can do the place to connect with people and all of that, but now it's just a spot to just. I mean, I watched some lady the other day on social media. She was exercising and doing something, and she showed her before and in the transition photos.
And people were like, what changed?
They were going in on her. And I'm like, wait a minute. Yeah. How can you go in on somebody for just, he says, I'm one of those commenters, Mr. Minutes.
But you want to know something? The crazy thing is that happens all the time. And a lot of times people post this clickbait. It'll be like before and the after don't look much different than the before. Because they just want you to click. Yeah. And then people get pissed off and then they start clowning you like you still look the same, or would you get an extra stomach? And so then it's like, oh, I'm being bullied. Like, but you did that to yourself, because why would you trap us with clickbait? We sitting here for 3 minutes thinking that you're going to change and you still look the same.
Yeah, that's true. But that's like I said, that's the nature of social media, man. It's like, look, you are going into the cafeteria like the new kid, and that applies to everybody. Anything you say is liable to get jumped on, and I have watched it, and I have watched Oh my gosh. I've watched so many. I go straight to the comments and I'm like, wow, I didn't know how y'all could start fighting. I mean,
it's crazy. I mean, these people be fighting for their lives. I said that during my last stream. I'm just like, like I said, it's a virtual psych ward because people be on there like going hard in the paint. I'm like, dude, you don't even know these people. What are you doing?
Exactly. Now, the social media harassment thing is, I mean, if somebody tells somebody to go disagree with you, and you know what, go over there and disagree. That is the nature of, I mean, that's a First Amendment right. You got protesters and counter protesters. We have that all the time. You know, I'm pro this, I'm anti you for being pro that. That's what happens. That's just the nature of life. It's dirty.
Right, it is. And two, I'm just trying to figure out how do you prove that?
Exactly.
I'm really wondering if she's going to sit there and bring up the maybe 10 or so content creators that have actually spent time on this case. And then when you do that, exactly what points are you going to bring up? We have free speech. We have the ability to disseminate information how we want to. Nobody's saying anything about you that has not been documented. So what exactly are you going to do? What is the proof going to be that he somehow got people that don't know him from a hole in the wall to say bad things about you?
And again, as long as I still follow the lines of, as long as you're not crossing the line into cyber stalking, actual stalking, or defamatory statements, it's protester, counter protester. And that to me is how I see it. And if you like, those people who made me feel bad about myself, well, you did not have to go on that thing. You could have made your account private. There are all these things out there, but
she could have turned off the comments, and she has many times.
Yeah, nobody has to make the space comfortable for you. I don't encourage people to trash people. I think we can be much more civil to one another. But, you know, come on. And as Daisy just said, none of y'all know this man.
We don't know him. I mean, I do now.
I mean, now, but at the time,
but
it's
before, no. I said, I didn't even know who he was as an actor before Creed.
Right, and then
I kind of put the pieces together when I went on IMDb, and I'm like, okay, this is the dude from this, this, and this. But yeah, nobody
knew him. I mean, nobody knows him like she said
personally.
Yeah, personally, and then like the other person was talking on here. I mean, what is he gonna? Did he reach out to his specific? Even if he reached out to a specific person and said, "I want you to every time she posts something about me, go in there and tell her about herself." Fine, because he could have done it as long as it doesn't cross the line into the cyber stalking, which Chillmonger stays away from. As long as
we thank you, Chill.
You know, as long as and I just want to give thumbs up to Mr. Minutes because I appreciated the Loki reference, by the way. Because there's Miss Minutes on that one.
Yeah, exactly. He's Mr. Minutes.
and she got predators who pretend to be victims wearing sheep's clothing. I like to say this. I find a lot of people, if you ever watch MMA, you got these jiu-jitsu people, they fight good from the bottom. You know, they'll go to the ground first and lay on their back. Like, come on. Because they know from that position, they can choke you out and do some damage. And a lot of people fight well from the bottom. You know, and it's like, I'm a victim. I'm like, no. Let's get this straight. If I take a snapshot, one snapshot, and I see this, I'm like, you know what? He sure did hit you. But then if I play the video and I go, well, that hit came after 3 punches and a slap by you, a kick, and then I'm about to hit you again.
Exactly.
So you fight good from the bottom and show us that one snapshot. But let's put the whole thing in context. And
what led up to that? Him doing that,
and he was trashed. And he was trashed. That's what that guy said earlier. He was trashed in the media. I mean, the media coverage for him was unfavorable.
To date.
I mean, what impact on his career? I'm like, wait a minute. Let me go through all the people who have been not just domestic violence. I got that, but all the other crimes. I'm looking at all these people. They're superheroes, you know. And somebody had a drug problem. I'm like, yeah, you do know that a lot of people get killed as a result of the drug trade, the drug transaction. We got all these these actors and people that are beloved who have. I'm like, yeah, they participated in the illegal drug trade. They're the reason people are shipping, cocaine or whatever it is to America. They're the reason. But we're like, oh, but they're a beloved actor, and it was a disease. I'm like, okay, I'm cool. I got you. But let's go through all the stuff that we're talking about. You know, all the evil rich. Everybody says the evil rich. I'm like, yeah, all the actors that you see to be talking about are rich. You know what I'm saying? They bought whatever, but apparently they're not evil. So it doesn't apply evenly across the board in terms of who gets villainized or when they get villainized and for what. But in a domestic violence case, I'm certainly not saying that domestic violence should get a pass. I mean, if you commit an act of domestic violence, you're gonna get dragged, and as far as I'm concerned, cool. You know, I have no problem with that.
But my thing too with domestic violence too, my mom was a victim. I don't know if you consider child abuse part of domestic violence. I was a victim. I get it. I understand it. But my thing is, if there's mutual combat to some extent, you cannot keep calling it or playing an angle of it being some one-sided domestic violence. Everybody's part of it.
Yeah, exactly. You know? You were not a victim. You were a participant.
Exactly. And we have to start getting into the nuances of that. Right. And hopefully, you know, if nothing else, because I'm not a Harvey Weinstein fan. I'm by no means excited that he's getting away with what he actually did do. My only thing is it sets a precedent for the Molineux stuff. But we have to also look at it from the standpoint of at what point were you participating and then decided, like I said, the hell that you chose was too hot. And now it's a problem. Now we got to sue. Now we got to start, dropping dimes because it didn't work out the way I thought it would work out. You know, the devil that you made the deal with started cashing in his chips. So, we have to start, normalizing, dissecting the nuances of a lot of this stuff.
Yes.
You know what I mean? Barbara, you better not be driving and texting to Kirby. She's like, sorry for the bad spelling, I'm driving. Yes, we have all the transcripts, thanks to Kat. And those who crowdfunded the transcripts, because it was a nice chunk of change just to get her testimony and a couple of the other witnesses. We didn't even get the whole trial, and it was like almost $3,000. But that's my thing. We have to start normalizing, dissecting the nuances of not only domestic violence or intimate partner violence, but these sexual assault, sexual harassment claims, all of it, because it's never black and white. It's almost always gray. And this is what the Harvey Weinstein reversal is highlighting. Not that he's necessarily innocent or this great guy or that, he should be vindicated, because he's a real piece of shit. But at the end of the day, if you're using inadmissible stuff to convict people, we can't do that just to advance an agenda. We have to stop doing that.
And I just want to let's go back to that Harvey Weinstein thing just to comment on this. If he's what you just described, how about the people that enabled him and let him go? That's such a broader thing. Like, it's not like this dude, like, come on, that man's like a toad. And you don't tell me this toad is with all these, like, no, you know what's going on. Everybody knows what's going on. And you're going to sit there and try and act like, oh, well, we're shocked. No, if he's a piece of, he's a piece of shit. Okay, cool. But so many other people are who are watching that, let it go on, who participated in it.
Happen.
You know what?
I dare say that the people making the accusations, I want to say at least 50% of them are a piece of shit. Because like I said, they chose that hell. It just got too hot. And now it's like, okay, I didn't get what I want. I didn't get my pro quo from the quid. And so now I want to sue, or I want to see him go down.
All of that happens, regret at the end of the day, even if you got the quid and the pro quo, you're just like, you know what? I went to bed last night and I couldn't sleep because I thought about it. And I thought about what I did and it just wasn't worth it. And it's like, I'm going to tell somebody and I want to say,
now I have daughters, because a lot of times that's usually where the buyer's remorse comes from. Now I have daughters this age, and what kind of example am I setting if I don't hold the man responsible for the fact that I, made stupid decisions? You know what I mean? I have something to prove to my daughters. It's always some,
It's always a noble cause, and sometimes you got to go, look, let's just be real. You did what you did voluntarily, and it was dirty, and I get it. And you shouldn't have been asked to do it, but you answered the call and did it. And so we have to deal with that. And I'm not saying that you deserve to be in that position, but I am saying that you cannot be rewarded because you followed through it. Mm-hmm. And if you want to go for this person, let's talk. I want to get everybody that was involved. Who enabled it? Who knew?
Right.
How did it happen?
Now, question. Unlike murder, because murder has no statute of limitation. Obviously, this
Correct.
does. Assault does. They cannot, like murder, you cannot hold somebody as an accessory to a crime in non-murder cases, right? Or because I do know they can be accessories to crimes in like financial fraud cases, right?
You can be an accessory to any crime out there. Except for every crime, if you help, you are an accessory.
So why is it that they don't ever go after, like with the R. Kelly thing? Those parents straight up admitted that they basically fed their kids to him.
It's
in the Surviving R. Kelly documentary series.
That's prosecutorial discretion.
Here we go.
I will say
exactly.
this: when I was a prosecutor, I'm going to tell you something that it's embarrassing to say, but it's a fact that I realized. I've had cases when I was a prosecutor where, after talking with the so-called victim, they admitted to me that they made it up, and they lied and they didn't tell the whole story. Mm-hmm. And you know what happened to them? Nothing. I dismissed the case against the guy.
You should be embarrassed.
I mean, but how you going? You're never going to try anybody like that. I mean, no. There've probably been 3, and I'll talk sex crimes. Probably 3 cases where, the woman was prosecuted for falsely making that statement. Otherwise, and that's just of recent. But it was hard to get sex crime convictions years ago. So to prosecute women for lying about sex crimes will necessarily drive us back, and they're willing to, and prosecutors, quite honestly, are willing to just say the benefit is we'll dismiss against the guy. Mm-hmm. And I'm not saying lying happens often. I mean, I'm saying, in my experience, it didn't happen often, but when it happened, nothing ever happened. We're just like, all right, we're gonna let it go. And and the way I got people to tell was, I'd be like, look, I'm reading the story here, and I found people have been pointing out the inconsistencies in the post right here. And I just tell them, look, here are some problems that I'm having with the case. But you know what? If you just tell me the truth, I'll make this case go away. But once we go to the grand jury and you testify under oath, it is what it is. Mm-hmm. And now that if it's not true, it's perjury. That's a problem, and we can't let perjury go. But I got some issues. I'm not telling you what they are. Mm-hmm. But you tell me what the real deal is. And if it's something other than what you said, we can fix it. And if it's not at all like you said, I can make it go away. And nothing is going to happen to you. And I'll take the blame for it. I'll tell your mama, I'll tell my boss that, or whatever. I'll tell your husband or whatever, that it was me and I decided not to go forward. And I've made that agreement with several women, several, teenage girls. I won't tell anybody. I mean, I obviously told my bosses and everything else, and they would just be like, no, it didn't happen. Or what came in as a forcible rape would end up being, okay, you're 15, this guy's 32, and you say he raped you in the elevator, but lo and behold, it wasn't that. It was statutory rape. He was hitting on you, and he still gets prosecuted, but it wasn't forcible. It was statutory. So I had those kind of examples. Tracy Woods, right on the point. Same with Diddy and the enablers. Most of these crimes committed by these people are all enabled.
Enablers and opportunists. Because at the end of the day, that video that was released on Diddy was unreal. Absolutely unreal, disgusting, deplorable, this, that, and the third. And I'm going to say but, because there's always a but. At what point, again, like I said, at what point do we start looking at the nuances of how and why people end up in these situations? And I'm going to say, I don't care. I don't care if I get any backlash or whatever, because I don't care. Right. But at what point, you Okay, so you have daughter. How many daughters you have? 2?
One. I have a daughter and a granddaughter.
Okay, so you have a daughter.
Yeah.
So let's say she's in, and this is exactly what Daisy says. Let's say your daughter is in the nightlife and into the nightlife of Atlanta. And she's always at the club. She's always hobnobbing with these celebrities because she's clout chasing. She wants to eventually get picked up by somebody because she's not trying to be a psychologist or whatever it is she went to college for. She decided, look, I'm not about that life. I want the soft life. I'm going to go try to find me a baller. She's going to the NBA playoffs. She's doing this. She's doing that. She finally snagged somebody. Everybody knows he ain't no good. But I got somebody. I found a mark. This is gonna be my meal ticket out. We know that this person is not a good person. You're not the first or the last to establish that, but he's a meal ticket. I'm gonna ride this till the wheels come off. I'm his type. We look good together on the red carpet. Whatever he did to them, he's not gonna do to me because I'm different. Until he does it to you.
Well, I'll say this.
So at what point do you hold your daughter accountable to that? Well, I told you, stay out of that lifestyle. You knew that this dude wasn't worth 2 cents in Chinese money, but you still, you knew he was beating on women and disrespecting women. You knew, but because you want to be so bad in this lifestyle and you want to, have these opportunities. You understand what I'm saying? No,
I do. I understand. I understand the factual background you're giving. I'll have my retort is, it could be a scenario where there's several women that have said he's done these things, but if it hasn't been adjudicated and you haven't heard it in a court of law, you only got his version of no, it didn't happen that way, and she attacked me and I defended myself. So you won't necessarily have the true facts to make that decision.
Well, in this case, it was said that she actually laughed when he would do it to the ex.
Okay,
and I believe that because I've seen in everyday life the side chick or the new chick, clowning the old chick because look how he's talking to you or sitting there watching him disrespect the ex because you're the new chick.
But the line I would draw is if he treats you poorly. Mm-hmm. You knew what was going on, and so you learned the lesson. Don't be with somebody that treats you poorly, and so you put yourself in a situation to be treated poorly by someone. But once they cross from poor treatment to abusive behavior, I don't blame somebody for that, because at the end of the day, because once the momentum is going, that flash over from poor treatment. You worthless, you suck, you whatever. Here's $1,000. It's that ebb and flow, and I very rarely find people who don't have some background damage in it. Either one or two things I've seen, and I'm not saying these are the only two. I've either seen one, somebody grew up in a situation where there was violence and there was whatever. So their red flags, on a scale of 1 to 10 in terms of red flags, they've experienced 1 through 4 so often that the first red flag for them is red flag number 5. Whereas for people who've never experienced that, red flag number 5 is, why are you still here? So you should have been going to red flag number 1 or number 2.
Right.
So for these people, I have to go, all right, so we're going to give them 4 red flags, 5, 6, 7, 8, 9. They're at 9 already. If you just say the first woman, you stayed through 4 red flags. All right, cool. Then you got out. I'm going to give this woman who's first acknowledged red flag based on her life experience
is the 5th one.
Is the 5th one. So that's number 1, 2, 3, 4. So now we're already up 8, 9, and 10. 9 and 10. So I say that scenario happens. In addition, I've seen women who you get love bombed or whatever by somebody, and they get in your mind. And I will say this: if you know how to manipulate people, you can get them to endure a lot until they stop. And that's the thing. A lot of women who are in abusive relationships or manipulative relationships, when they get out, even women who will tell you they didn't grow up like that, you will ask them, and I have asked, because I was gonna write a book on this, but I have asked, and they'll just be like, it's like I lost myself. I didn't know. I couldn't see. It was, by the time it got there, I finally got out, and now I'm out. Thank you, Daisy. And so now it's like, okay, but why were you there? So I can't blame a victim for being a victim.
Well, no, I'm not blaming, because like I said, I've witnessed it and experienced it myself. And nobody had money. We went to projects. This had nothing to do with opportunity or wanting to be, well, okay. It was not, that was not the case. Even though my dad was a professional musician and we did have access to certain, music, but that was not always the case. So it's not like she found him doing that. They met in middle school.
Okay.
Yeah, so, but that's what led to it, because he, like I said, got hooked on the booger sugar when he got with the Bobby Brown. And Bobby Brown get blamed for everything. But yeah, that's when it started, though.
Don't blame Bobby, man.
That is when it started, when he went on that tour.
Right.
Yeah, when he went on that tour, that's when it started. So they parted ways when I was 13, because it just really got really bad. But
think about that. 13.
Yeah.
You see what I'm saying? That's years of red flags, and then repeated red flags. And
a lot of years.
That's what I'm saying.
I want to say at least starting at starting at the first extra kid. So when I was 4.
So when you were 4, that's the first extra kid. So there you go.
The first extracurricular child.
Yeah, that's just the child. That's just betrayal. That wasn't even all the other stuff. So I'm just saying that it's complicated. I mean, and I'll use this example, my own example. And it's not violence or anything. I didn't go through that. What?
He was the Cosby kid.
My house is the Cosby right now. People think I'm joking, but I lived. My wife's a doctor. I'm the lawyer.
I was one of the Evans.
Yeah. Thelma, there you go.
Projects.
Oh. No, when my parents were going to school, it's different. My dad was going to school, it's a little bit different. But my point is this: sometimes it's just how your brain works, and you don't know. I like to eat, and my wife likes for me not to eat some of the things I like to eat, and one of them is oatmeal raisin cookies. I love them.
Oh man, have you tried Tate's?
Oh, that Tate's! Come on, the crispy. Look at there. You about to make me go get a bag on the way home and eat it in the car with the milk.
Tate's right in my closet now. Those oatmeal. Woo!
Look, I will eat food on the way home and then eat dinner like I didn't eat food. You know what I mean? I mean that. So anyway, my wife's like, you want another plate? I'll take another plate. Yeah. Boy, why do you smell like pizza? I don't know.
I don't know.
Because I eat pizza. But anyway, here's the thing though. When I was going for an oatmeal raisin cookie, I was a prosecutor. I work in high stress cases. I deal with a lot of stress all the time. I'm used to stress and making decisions rapidly and all that.
Right.
You know what my wife did? I was going for my oatmeal raisin cookie. She said, you can't have it. I said, I'm going to get it. All she did was stomp her feet. She just stomped her feet. Froze me in my tracks.
Right.
I stood like that. And I watched her. She didn't run. She walked and got my cookie and ate my cookie. And I was like, how is it
there's only 14 in the pack, man?
Who can do all of this stuff was stunned into silence and by you just stomping your feet? So sometimes when you're in situations where stuff is coming at you, you know how you're going to react after the fact. After the fact, we all have that experience.
Hindsight.
Yeah, I should have said this. I should have said that. Well, same for these women or people who get victimized who kind of go, I went along with it, but you know what I should have done? And they should have done it. Now, others who are clout chasing, as you indicated, and there is a different category. I don't put them all in the same category. Like somebody else said, I certainly reject Hillary Clinton's statement of I believe all women, because she couldn't believe him when Bill was in office. But still, what I'm going to say is she helped trash them, as a matter of fact. But what I will say is this: you have to look at the situation and give everyone their fair due. But the women who are clout chasing, I'm like, you know what? You're clout chasing, and they treated you poorly, and you were willing to trade poor treatment for the access that you thought that you were getting. Not that you actually got, but that you thought you were getting. And you were literally probably going to go from this dude to that dude to another dude, and you're going to keep doing your thing and get on and make big money for you. Not necessarily big money, but big money for you. But once they cross the line into criminality and actual abuse, they're taking advantage of you because they know what you're trying to get. And they know once you get in so deep, then they shut the door and lock it. And they're like, well, you walked in the room. Now, I came in this room. I didn't come in for what's about to go down. I came in for something totally different. And so But in that dynamic, that's how true predators really roll. And they roll by saying, come on in. This is what I want to give you. And then they lock that door and they just go over the board and they'll just say, you brought that on yourself. But, you know, or here's $1,000. Here's $10,000. And, you know, 10 grand can be life-changing for some people. I mean,
I think it's just all weird because, like, I don't know if he's still with, but he was with this really young girl named Young Miami from this group called City Girls. And she's probably young enough to be his child because he's about 55, 56. And
I don't get that.
You know, a lot of stuff came out about the different weird kinks he had. And prior to any of this Cassie stuff, she was on I think it might have been her own podcast where she said she liked being urinated on. So I'm saying that to say, I'm only saying that to say, so now is she going to come out later and say that he peed on her and she didn't like it after she went on a podcast bragging on it like it was a flex?
Well, or is she going to say,
because to me, that's a non-negotiable. Like, there's absolutely no way in hell.
Or I'll throw this out there. It's like the porn girls, the women who deal with porn. They'll sit there and say, "Oh, I loved it. It's great. It's awesome." And then
when you're done,
they're like, "No, I really didn't like it at all. You know, I was abused. I was on drugs. I was doing whatever." But because in order to keep getting, who's going to watch a porn film or whatever they flick or however they come out now? Who's going to watch one of those where the actor? I mean, there actually probably is a crowd for this, where the actress goes, "I hate it. It's terrible. Every day I go and I just can't deal with it." And
but then again, though, Kirby, you chose that hell. Nobody held a gun to your head and said, "Go be a porn star." A lot of them have similar stories. Many of them grew up like Huxtables and just still decided to do that. And, you know, that's where I have trouble. I have trouble with that when you're okay with the stuff until you're not okay with the stuff.
You know what, and I get that 100%, but I am the kind of person who, my parents were in the ministry, my father was, he's
you would never.
So I get to talk to people. So I will talk to people, and I'm the kind of guy that if I'll ask, because I can ask you stuff. I don't know. I have a way of asking offensive questions in a manner that makes you want to answer me. It's just like, hey, since we're talking about it, let me ask you some things. Because I'm not going to judge you and just be like, that's stupid. I want to know how you think. Mm-hmm. I'm going to ask my questions. And when I talk to people who've gone through stuff and they explain it through me, I kind of go, okay. And I'll tell you this example. It's a better example. I remember I came home and my son had some friends over at the house. Mm-hmm. And they were sitting on the couch and the chair and they were watching TV. And nobody got up and nobody changed the channel. And I was like, I'm sorry. And I'm looking, I'm like, how y'all doing? Everybody's like, how you doing? Hello, sir. Good evening, sir. All the polite stuff. Mm-hmm. But nobody moved. And nobody offered me the remote control to my television. So I then tell my son, let me holler at you for a second, man. Because I'm about to say, I'm about to tell folks what
everybody
they can do.
Out of here,
yeah,
right?
I'm like, let me talk to you for a second, man. And I'm like, what's up with your friends? How come they're not getting up? And me and my son talked about it. And he told me, he says, the reason nobody got up and moved or left is because they felt that would have looked suspicious to get up when you walk in and walk out. And I'm like, why would that look suspicious? And then
what are you doing? Like, what are you?
But that's what I would have thought. That's what they thought I would have thought. I would have just thought, you see that the man in the house is home, get up out my spot and give me my remote control. But he was like, so their way of showing you respect. So I'm just saying, people think different ways. And once I came to learn how varied those ways were, and even how stupid some of the ways were, and that was stupid. Mm-hmm. I made sure everybody understood, hey, in the future, when I walk into the house and into the room,
part like the Red Sea.
Yeah, literally. You all can sit where I'm not sitting and not the next spot next to me, because my wife's probably gonna sit right there. So anywhere else, and I better have the remote control in my hand. And oh my God, don't be eating my food and sitting there looking at me.
Oh yeah, that's a big pet peeve of mine. I don't touch my food, don't go in my fridge.
We feed everybody. But my thing is, if I'm sitting down and you're eating, and I walk in the house, first of all, you should be eating any dinner. You got a snack, cool. But if you got a plate and I haven't eaten yet, there's a problem. What are we doing? You better be like, oh, sir, you better look like, who put this plate in my hand?
Like you're a little too comfortable.
Like you a little too comfortable in my house, man. So, but anyway, but I think it's important to see where they come. But I get the point that you're making. And as far as Grace Jabari is concerned, I think a lot of that goes in there. And being fair, and I have to be fair in this regard. It could be not that he broke. I think that finger breaking. I don't believe
I don't think that happened. Not by his hand. I think it was an accident, but she caused it. Yeah.
But I think that, and that's really my ultimate conclusion on this case is that I think that there were some abusive behaviors that happened before. I think he may have put hands. I think he may have stomped, may have pushed her. He may have done something that when she had to go to the hospital for, she didn't go. I think all of that happened. I think that that's reasonable to believe, but it wasn't charged. And on this case right here, she attacked this man because I think they had a dysfunctional relationship. It was just purely dysfunctional. And I also don't think it was abusive one-sided.
Right.
I think that there was, both of them had issues because they were together. Because I'll tell you, I like peace. You know what I'm saying? When I was in college, it was, girl, you don't bring peace, baby. I'm sorry. There's one thing I don't do is drama. So I don't even do it. I don't even say deuces. You just don't see me anymore.
Right. And it was easy to ghost people before cell phones and social media.
Absolutely, man. It's like, yo, like you haven't been around. I know. Everything okay? Everything is cool. You know, we are straight, but we still ain't kicking it because no. So I think that there was that aspect. There was the volatility. There was just a dysfunctional relationship. And I think that the abuse, emotional as well as physical, went both ways.
Oh, definitely.
And I think that on this date that she attacked him, it was caught on video. She got hurt, and and the prosecution just picked her. Right. And I'm saying that the reason you picked, if you did a thorough investigation, I don't know why you just picked her. Now, there's these other women who have these other claims about whatever he did. Those claims never saw the light of day. They never saw a courtroom. I don't got any arrest records. I don't know whether I can't credit those claims. And maybe he was just arrogant and told you're beneath me. Because that one lecture to her about, Coretta Scott King and Michelle Obama. I mean, it's almost like you need to be at my level because of where I am. And maybe he made women feel bad that way. And hey,
but he qualified it though. He kept saying this was the plan.
No, but that's what I'm saying.
Not following the plan. It wasn't like he just pulled it out of his ass. Like, yeah, you need to act like these people. We already agreed that you were going to carry yourself a certain way, and you're not doing that.
But see, I'm fine with either one. He could have pulled it out of his ass and been like, baby, I need you to be like Coretta. And she could have been like, I'm not Coretta. And she could have got to stepping. Or he could, but when you have a plan, it's like, well, this is such an abusive plan. Chick, are you making the money he's making? Are you doing the things that he's doing? I mean, we're going to ride your star to where? You ain't got a star. We're going to ride your little red wagon down the street.
Yeah, your little red, what do you call that thing? Radio flyer down the street.
Yeah, we're going to ride your radio flyer down the street to the little shack. Or we can stick with this plan, and this plan needs these things. And you might say that's arrogance.
In one of our other things, when you're in a relationship with somebody, especially somebody that you're supposedly going to marry, everybody has a plan. Whether it be how many kids you're going to have, where you're going to live, how much you're going to spend on your house, whether you're going to have pets, whether or not she's going to work and you're going to stay home, or vice versa. Everyone has a plan. And when you deviate from that plan, somebody's going to get upset. We just don't get recorded and being upset and whatever we say in that moment.
Now I'm gonna hit you with something really crazy. This is I don't play the race card, but I want to bring this issue out.
Well, I do.
Well, I know, but I mean, when I call it out, I hit it. But here we go. We got either you look like a thug, dress like a thug, act like a thug, and so therefore you're a thug,
right?
Or you're too uppity, and we got to bring you down a peg. And the way we bring you down a peg is to make you a thug.
Yeah.
And that's where we are in here, because I still got to go. Why did her tears carry the day? Why was she not prosecuted for attacking him when she admitted doing it?
And admitted it, and you can see it on the video.
And it was the same level crime. So we got the same level crimes, and she admits it. That's the key point. She admits it. And when you say
under oath.
But I'm sure she admitted it before that too.
Oh yeah, she did, because she said it in the text messages.
And as a result, they made a preference of too uppity or a thug, or you an uppity thug. But either way, we're gonna bring you down some notches. And the way we do it is we'll give her a pass. And why are we giving her a pass? Because he's a thug. Mm-hmm. And that's the point, because she didn't deserve a pass at all. You should have prosecuted them both. And you could have said, y'all both got the Fifth Amendment right out there. You all want to invoke it, or we're going to take you to trial, then we're going to take you to trial. And
or y'all can both just plea out and get the hell on.
Oh, they would have just had to dismiss. But see, they didn't do that. And they made a preference. And my only point with them making the preference is, how do you make that preference and ignore your own police department? And you say it's retaliatory. And as I told you, retaliatory versus true, those aren't the same thing. And they use that language to create the impression that it was retaliatory and false, but it was retaliatory and undeniably true because she admitted it, and they still did nothing. And that to me is emblematic.
Appealable, and something that he can do in a civil countersuit.
I would, if I appealed it, I would appeal it and raise a equal protection claim. But that's going to be. I mean, I don't think he'll get anywhere with it. But it's worth talking about, because that is a real issue that really should be talked about. Because if you're going to say that this man should lose his career and do all these things, let's also talk about the fact. Yeah, okay, domestic violence, cool, but she admitted to engaging in criminal acts against him. So we got to keep that in perspective. It wasn't domestic violence against a woman who's like, "Why are you beating me up?" This was, she was attacking him, and you say he did whatever he did to her in the context of her attacking him, actually, by the way. So self-defense. But all I'm saying is, are they showing Diddy doing his thing right now? But at the end of the day, why did you make that preference? So we need to make America have that conversation. Why does he, the black man, have to lose everything? Why is everybody dropping him? Went under the auspices of, well, he did bad. No. He did bad, but she did the exact same. And so within that context, the consequences for him are far greater than they are for her. And she never actually paid any consequence. And so we need to
I think that she's unemployed, because she did allude to that in the victim impact statement, but that's by your own hand.
Well, she's unemployed, but she's also but she also had, as I understood, a drinking problem. All right.
She had a drinking problem, and it was brought up on cross. It was objected to and sustained, but it was brought up by Priya that her family had issues with her drinking, that her drinking was a bone of contention in her relationship with Jonathan. And then what was not objected to and sustained was her expert witness from Bellevue, like I said, saying that she failed the audit fee 3 different times. They tested her 3 times over the course of 2 hours, and she failed it. And failing that meant she had
the hair test, not the hair follicle. When they cut your hair and they check and see how much stuff you have in there.
They didn't do that. It's an audit fee. It's like a survey, where you have to answer a series of questions, and then when they add up all the numbers or whatever. The number that they did. Yeah, so I guess on a scale of 1 to 5, she was like a 3. And that 3 means she failed. And that she had alcoholic tendencies.
Well, then an unemployed alcoholic tendency having violent woman who is unemployed, to me, I'm like, well, the unemployed just kind of goes without saying. I lost my job.
She was unemployed at that time because she didn't have a work visa for the United States.
Oh, come on.
And she was trying to get him to sponsor her. This is what I'm saying. And only 3 days before the incident, they had it out because she was trying to get his work schedule, and he told her to stop scheduling her life around him and that he was not going to give her his work schedule. And she tried to drive drunk from Sag Harbor back home, and obviously didn't because she was drunk, so she didn't leave. But this was only about 3 days before the incident. So she started writing on the wall. That's why I think she flipped out.
Right. No, and that's the point, is that's what I'm saying when they say, I'm sorry, I done spilled something on myself. I'm trying to, where's my, I had it balanced on this desk that I lost track and raised my leg and bumped it, and now it's on the fence. And I'm like, this is a brand new pants. I mean, literally, my first day wearing them. Oh well. So anyway, but that goes to my point again about why that preference. Why that preference? Like, you can't even say she was, I'm not saying that she had to be pure, but I'm saying you can't say that this is someone who had a lot of motives to fabricate a lot of things. And we've already discussed that before, because I remember I still was like, yeah, look, I get it, the green card, the work visa, the alcoholism. There's a lot, and you just kind of got to go, wait, what did you have going for you?
Which Nothing. Is why she owed the. Why did I say and these little bubbles picked up? Okay, thumbs down came up when I said owed, but she owed the equivalent of the IRS in Britain $25,000, and she tried to get him to pay that too. So she had a $25,000 tax bill. She did not have a work visa and wanted to stay in the United States. She was diagnosed by Dr. Chang at Bellevue Hospital. So in case you want to say I'm defaming you, he said it. At Bellevue. Alcoholic. He was diagnosed as an alcoholic by him and in direct testimony under oath. So she had a lot going against her at that point. Right. And then the fact that he was throwing not so subtle hints that he did not want to be with her way before that text message and that car exchange.
No, he subtle hints. He was sending her direct statements.
Oh, he was sending her a lot of hints for about 8 months straight. We did an episode on that too. Me, Pam, and Kat. We had the whole timeline, but the most recent one prior to the incident was, I want to say, March 19th, and the incident was March 25th.
And that's why I say that the preference was an issue. But at the end, I think to go back to loop back into what we began talking about, I think that the Weinstein issues may help, but I don't believe that because it's a one witness case and the opening the door, I think the claim is going to be something totally different. So there's going to have to be a charge. It's going to be more on the charge of the charge to the jury or the exclusion of some evidence, which would be critical in this particular case. Yeah, and maybe keeping the detectives from testifying to certain things that really change the tenor of the case, because the evidence was far from overwhelming. And because of that, when you start trying to determine whether error is harmless, if you will, you want to consider, well, if the evidence is overwhelming, we got you on video, we got 9 people saying you did it, your confession, so they didn't let me bring out my mama to say whatever. Bruh, it's not going to make it. Yeah, that's true, and that was an error, and our bad, but the evidence was overwhelming, so that error was harmless. Right. As opposed to the evidence is so much closer. There's not much tolerance there. You know, it's real close. And so keeping something out like this could genuinely have changed the outcome of this case. Right. And that to me is what he has going for him. And I'm going to keep hanging on that background knowledge too. A lot of that was prejudicial. I feel like a lot of that did not need to come out. I think you are perhaps correct. I didn't watch the whole trial though, so. No. I mean, I could send you I'm telling you, and I have the transcripts just because I made sure that I refreshed my memory and I wasn't, being delusional, because I was as unbiased as I could be in terms of relaying the information. I was not unbiased in terms of whose side I was on, but I was unbiased in terms of how I heard things, and I made sure I let everyone else know what I heard. So that they could, and then when I got access to the transcripts, I was like, okay, so I did hear correctly. I was not, using creative license because I just wanted this dude to not be guilty. And I think that to me is a fair way to look at stuff. I know who I want to win, but I also got to look at the facts too and kind of say. And I did admit openly on several different people's streams that her first day of testimony, I was like, oof, this is not looking good. But then once Cross got to it, it started crumbling. And then that's when I was like, okay, now we see who the real person is. And that's where I think he has, to the extent that they opened, well, again, we talked about that. I think it may not be that. It'll probably more so be the exclusion of some testimony is probably the better part. The better angle to play. And I think especially the torn clothes, because the fact that they couldn't really pinpoint when this happened, and then somebody pointing there how she was using her fingers at the restaurant and all the other stuff. And everything else, right. Yeah, so it's like, well, we really got to figure out, did you break your finger earlier and just went all the way through the day because you were just too drunk to feel the pain? Or did you break your fingers later because you were too drunk to walk up the steps? Did she fall up the steps?
She ran into a wall, like kind of stumbled into the wall on her way out of the club.
There you go. And I've seen some injuries happen in some really weird ways. So.
Oh yeah. Like I said, I hurt myself so much. I'm literally about to tattoo all the way down to my wrist just to hide the bruises because because they don't go away. These bruises are like 10 years old, and I'm still trying to get them to go away. So I'm like, you know what? We just gonna make this a sleeve so that I can get rid of these two, looking like I've been in a knife fight. And these are literally iron burns. This is why I don't iron anymore. But because I'm just like, I'm always hurting myself, so I'm not above a broken finger. And
I just want to know how do you iron? I mean,
I don't.
What you be in there doing?
Well, because like if it's a pair of pants and you're pulling up the leg, and then my arm might hit the side of the iron.
No, I got
never fails. I'm always burning myself. That's why I'm
covered with bruises, marks, and all the other stuff.
The tattoos. I'm just tattooing them because it's been about 10 years and nothing I've done has faded them. But so we're not gonna keep Kirby much longer. Thank you guys. I forgot to say, please follow. There's 77 of you in here. I think more than half are on Twitter, so that's why.
Right.
But come on YouTube and because like 22 are in YouTube, another 50 some odd are in Twitter. So if you can come on YouTube, please follow, share. Kirby's contact information is in the summary for this episode, as always. So if you do need a criminal defense and or appellate attorney in the Atlanta or Georgia, in the state of Georgia, and I'm going to always do this, New York. Kirby, if it wasn't for the Molineux evidence, that was the people wouldn't have talked about Coretta Scott King. And that's true. That is true. Everybody said thank you. Danny,
thank you all for listening.
Thank you, Kirby, as always. I'm going to leave Kirby alone for a little while because really, we just got to wait and see what happens with the appeal, what happens with this civil. He has until mid-July to file the counter. So that's a long way from
he's got time.
Months have been flying by. It'll be Christmas again next week.
Hey, look, they might work something out.
Yeah, we got about 2 months before Jonathan has to do his counter to the civil.
Okay.
Still have not seen anything about that appeal. So I don't know if my math is off or if something was filed that we don't know about, but that time has well expired to file that appeal after sentencing. So I don't know what's going on with that, or if it's one of those situations where they haven't uploaded the documents, which is highly probable because New York is good for that.
Yes.
Where they do not upload anything, the motions or anything.
Yes.
So it could have been filed and we just don't have access to it. I didn't ask because I'm minding my business, but drinking my diet lemonade and minding my business. But thank you again, Kirby. As always, we appreciate you.
Oh, thank you for having me. I appreciate being had.
Yeah,
I haven't gone anywhere.
Go get your Chick-fil-A.
I really am going. You held it up, and I'm like, she don't even know. I'm sitting here fantasizing about my Chick-fil-A diet lemonade and tea. I'm like, oh my god!
And top it off with some oatmeal raisin cookies.
And look, I'm gonna actually eat Chick-fil-A. I'm gonna eat the whole meal and go home like I didn't eat. That's really gonna happen. I'm letting y'all know this. I'm gonna come home. My wife's gonna be like, because we're eating plant-based now, so I'm losing weight. But I'm going to lie by omission. I'm going to eat the spicy chicken sandwich and get home. All that's gonna happen.
Oh my Lord. No, that's funny. I'm telling Suzanne. But even better than the Tate's. That's my inner fat girl. Sorry. Even better than the Tate's oatmeal raisin are those hot Chick-fil-A chocolate chip cookies.
Now, see, well, you know what?
Have you had?
What the problem is, I'll be drinking. It doesn't go with the lemonade. I gotta have milk. So
almond milk.
So I'm gonna get I'm going to go get the, well, I'm not going to say what I'm going to get because I'm incriminating myself online.
Right, right.
I've learned from the Young Thug trial,
At 2 hours and 14 minutes and 11 seconds, Kirby said,
I'm going to go eat Chick-fil-A and then go home and pretend I haven't eaten, which I have done before.
You are terrible. Oh, man. Now I got to look at my husband like, do you do that?
We all do it.
Y'all greedy. Well, thank you, guys. Thank you for coming. Please like, share, comment. Follow the fan page on Facebook and Instagram. All that's in the show notes, the bios, everywhere. Give Kirby a call if you need his assistance. And I will see you guys next time. I'll be doing something. I don't know. I don't want to disappear for too long, but thank you guys. Good night.
See you later.
All right.